Hey folks, James Abrenio coming to you from Abrenio Choe. We are a criminal defense, personal injury, and a medical malpractice firm in Fairfax, Virginia, practicing throughout Northern Virginia and oftentimes throughout the state. It is January 16, 2026. Today I wanted to answer a question that I get a ton when it comes to cases involving criminal charges. So folks will call me and say, "Hey James, I've been charged for this absurd thing, whether it's an assault, whether it's some traffic infraction, whether it's something else," and they'll say, "James, isn't there a way to just get the charge dropped? Isn't there a way to not have to go to court?" I get this a lot in domestic violence cases where somebody will swear out a warrant against the significant other, then later on they decide they don't want to go forward. They've communicated it to the accused, and all of a sudden now they say to me, "James, can't we get the case dropped?" And my unfortunate answer to folks is it just doesn't work like that here in Virginia. Maybe in other states, but at least here in Virginia, there is no authority for the prosecutor, for the officer, for anybody to have the case dropped without it going to court. And in order to understand that, Virginia actually has useful authority on point, so we can take a look and get actual guidance. So we're not just kind of talking speculatively. And so what I'm pulling up now is in Virginia, the Attorney General will typically write what we call legal ethics opinions. So if you know anything about your state politics, you have the governor, at least here in Virginia, you have governor, lieutenant governor, and the Attorney General. The Attorney General is really the top lawyer of the state. We often say that they have the biggest law firm in the state. They help us understand laws. They help file suits on behalf of the Commonwealth. But one thing they also do that's so important is they issue what we call legal ethics opinions. Hopefully, these are non-political. It's really technical views on law that is not explicitly laid out by the legislature in the code, in the Virginia laws. So there's some ambiguity there. So oftentimes what either representatives will do, or sometimes you'll see in here, judges will do, is they'll write to the not to the General Assembly, they'll write to the Attorney General and say, "Look, I want a legal opinion as to whether or not I can do X, Y, or Z." So here you're going to see this scenario where you'll see a judge, Honorable Ralph B. Robertson, judge the Richmond General District Court. This is May 30th, 2003. So the Commonwealth the Attorney General at that time was Kilgore. I don't know a whole lot about Kilgore. That's kind of this is around the time where I think I was still in law school and still just trying to survive at that point. So I wasn't paying attention politically in that regard. But Kilgore wrote a legal ethics opinion, and this is dated May 30th, 2003. The legal ethics opinion is 03-025. I'll put this. I'll try to put this in the show notes, but you can Google it as well. But essentially, this gives guidance for when what a judge can do in that scenario, what can happen in that scenario. And you can see here, it's pretty straightforward. No authority for chief of police or Commonwealth attorney to withdraw or dismiss lawfully issued arrest warrant or summons to, quote, unarrest, end quote, person lawfully arrested on a warrant or summons, or for the Commonwealth's attorney to dismiss a misdemeanor or felony charge leading to a lawful arrest without showing good cause to the court. What that effectively means is nobody besides the court has the authority to essentially dispose of a charge. And so as we get into the reasoning here, let me just lay this out. We're going to go through this in a lot of ways, line by line. You asked whether the chief of police, the Commonwealth attorney, may withdraw or dismiss a lawfully issued arrest warrant or summons without judicial approval. You also asked whether a police officer or Commonwealth attorney may unarrest a person. Finally, asked whether or not the Commonwealth attorney has the discretion, authority to dismiss any misdemeanor or felony charge that led to an arrest without showing a cause to the court. It is my opinion that neither chief of police nor Commonwealth attorney has the authority to unilaterally withdraw or dismiss a lawfully issued arrest warrant or summons. It is also my opinion that there is no authority or process by which a police officer or Commonwealth attorney may unarrest a person who is lawfully arrested on a warrant. It is further my opinion that the Commonwealth attorney has no authority to dismiss any misdemeanor felony charge that led to a lawful arrest without a showing of good cause to the court. We're just going to kind of zoom through here. And I'll let you read this entire opinion, but they refer to section 19.2-72 provides that an arrest warrant shall, quote, command the accused to be arrested and brought before a court of appropriate jurisdiction in the county or city in which the offense was committed. Section 19.2-73 applies to misdemeanors and provides that any person whom a misdemeanor summons is served shall appear on the date set forth in the same, and if such fails to appear on the date shall be treated in accordance with provisions of 19.128. So just referring now to the specific statutes, we're looking at 19.2-72 when it may issue and a complaint of criminal offense to an officer authorized to issue a criminal warrant shall examine the oath of complaint. Written complaint shall be required if the complainant is not a law enforcement officer. So this is talking about how the charges originate, but it also goes on. The warrant shall be directed to an appropriate officer, name of the accused, his set forth description, describe offense charged, command that the accused be arrested and brought before the court of appropriate jurisdiction in the city, county, or town in which the offense was allegedly committed, and signed by the issuing officer. So there is where 19.2-72, where the Attorney General is reading that under that statute. So then we also go to 19.2-73, issue of a summons instead of a warrant in certain cases. So summons essentially allow somebody to not have to be effectively arrested. They can sign for and not be held. In a misdemeanor or cases involving misdemeanor cases, having responsibility, the magistrate may issue authority to summons instead of a warrant where there is a reason to believe the person is charged will appear for court and having jurisdiction. So essentially the magistrate doesn't have to make any bonding decisions, that kind of thing. Let's see. A person who such summons is served shall appear on the date set forth in the same, and if such person fails to appear in such court at such time, he shall be treated in accordance with provision of 19.2-128, regardless of this disposition. If you click on 19.2-128, penalties for failure to appear. So essentially, you're going to be issued a failure to appear warrant where you can be arrested, all that. So just have to be aware of that. Okay. Now, going back to the legal opinion, they go on. Finally, you ask where the Commonwealth attorney has the discretion to dismiss a misdemeanor or felony without the showing of good cause of the court. And section 19.2-265.3 provides that a no pros, and I did a separate video on no pros when they can essentially, Commonwealth can drop, shall be entered only in the discretion of the court upon a motion, the Commonwealth with good cause. So when we look at 19.2-265.3, you look at this, here's the statute. No prosequi shall be entered only in the discretion of the court upon a motion of the Commonwealth with good cause thereof shown. Okay, so that is saying that the court has to be involved, even if the Commonwealth's moving to null pros that charge. So this legal opinion lays it out pretty clearly. There's not a whole lot of wiggle room there. Again, I have folks calling me and saying, look, can't we just get this case dropped? There's no need. It's BS. Do I even need an attorney? That kind of thing. Look, at the end of the day, and I always tell folks, look, these videos are not meant to be legal advice. I'm not your attorney. If you want me to be your attorney, you got to call me and retain me, and I've got to agree to represent you. If you have your own attorney, then they need to be helping you through these things. I'm just telling you, when folks call me, I am very straight up with them. It has to go to court to be able to be processed. Not saying you're going to be convicted. I'm not saying that the Commonwealth's not going to ultimately drop the case. I'm not saying that the complaining witness isn't going to recant or decide that they don't want to go forward. I'm just telling you that the process has to go through. And the legal opinion from the Attorney General back in 2003 agrees with me. Now, just to be clear, these legal ethics opinions, these legal opinions from the Attorney General, they're not law, okay? It's not like if you violate these, you're automatically in violation of the law. Legal ethics opinions really give the ability for judges, for representatives, sometimes even for attorneys to reach out. And frankly, I think even a citizen can do that to get more guidance in scenarios where there appears to be some ambiguity in a statute or in a scenario. So they're not law. That being said, the attorney general is a powerful position, and part of what we want in that representative is to give us guidance on the law. So if you are concerned about something, they can give more guidance. So again, it's not law, but I'm just telling you that this is what typically they will look at. Now, again, feel free to do your own research. If you want to represent yourself, you abide by the decisions that you make and suffer those consequences. But I would recommend that if you've been charged with a crime, reach out to an attorney. If you're in Fairfax, you can reach out to us. You may watch this video and decide, you know what, James seems arrogant. I don't like him. He doesn't seem smart. Whatever you want to do, you don't have to call me. But I would absolutely recommend, if you're charged with a crime or being investigated for a crime, speak to an attorney. Most criminal defense attorneys will speak to you with a free consult, and so you don't even have to pay them for at least some initial guidance. And ultimately, if you're charged with a crime, you need to retain one or have a public defender appointed. I'm a big fan of the public defender's office here in Fairfax, and I think Prince William's great, Arlington's great. There are a lot of good offices in this jurisdiction, so I'm not saying you have to hire an attorney, but you need an attorney. So hopefully you found this information useful. Feel free to reach out with questions, comment below if you have disagreements, all that. But I also ask you to like, subscribe, and share, trying to reach as many people as possible with useful information.